Our first case is Harrison versus Department of Management Services, Division of State Group Insurance. That's 23-1674. Counsel, are you ready to proceed?
Yes, Your Honor.
And before we get started, would you like to reserve some time for rebuttal?
Yes, please, Your Honor. 4 minutes.
4 minutes, so noted. Thank you. You can proceed when ready.
May it please the Court. My name is Michael Orr, and along with Katie Crowley and Kevin Cook, we represent the appellant, Arnold Harrison, who asks that this Court reverse the trial court's order granting dismissal of the second amended complaint as to the department. We understand that there are a number of issues in the briefing for both cases, but for this particular oral argument and subject to the Court's questions, we'd like to make 2 points and address 2 points for this appeal. First, the trial court did not exercise independent judgment in making its ruling in entering the order of dismissal. And second, the trial court erred when it dismissed the class allegations in the complaint without allowing class discovery.
Can you first identify which count has a prayer for relief against the department?
None of them do, Your Honor.
So why are we here with respect to the department?
They're a nominal party, Your Honor.
What does that mean?
So,
other than the obvious that you named it in the caption and nowhere else?
Yes. Whenever there's a case and you're seeking relief against one defendant or one party, and they may claim that another party is an indispensable party, which Blue Cross has done throughout the proceedings, you can add a party as a nominal party that you're not seeking relief against them, but they're an interested party in the case and arguably an indispensable party according to one of the defendants. So there's no relief against them.
So, I mean, if we were to, affirm the dismissal, at least as to this count, does that have any negative effect on your client at all?
I suspect, Your Honor, what Florida Blue would argue to this court is that if we didn't have DSGI as a nominal party or involved in the case, that we would have failed to add an indispensable party. And so by this court's ruling, if it were to affirm and find that the state's not a proper party to the case and that they're not an indispensable party because whatever ultimate determination is made by the trial court would not be binding in some way on the state, then that we submit would foreclose the argument of from Blue Cross that they're an indispensable party. Because if Your Honor, in reviewing the record, will note, throughout all the arguments on the motions to dismiss, Florida Blue has taken the position that they don't have the right to do anything in this case, that the state is the insurer, that the department is the one that makes the decisions, that the department is the one that makes the findings. We certainly disagree with that, and those aren't the allegations of the complaint that's before this court. But that's the position that Florida Blue is taking.
But yet you went ahead and named them, so you were playing along. So isn't that a concession that they are an indispensable party, or that the department is an indispensable party? Like, how can you take the position that they're not an indispensable party, but name them as essentially as an indispensable party, as the excuse for not actually seeking any relief against them?
And Your Honor, for clarity, we haven't taken the position, because we haven't gotten to that point. Failure to add an indispensable party is an affirmative defense. There haven't been any affirmative defenses pled in this case. We haven't gotten to that stage yet. So my client hasn't taken a position one way or the other than adding them as a nominal party as an interested party in the case.
But that is taking a position, because you're saying that they're an indispensable party. You just said that's why they're named as a nominal party, is because they're indispensable, or as a preemptive move in case they argue in an affirmative defense that they're indispensable.
Well,
I mean, don't you have to take a position now?
Yes, Your Honor, and I think by virtue of our pleading, we've done that, and that's why they've been added. And certainly prior to this pleading and prior to the second amended complaint, Florida Blue has taken the position throughout all the arguments that the state is in fact an indispensable party and the one that's making the decisions. So based on the arguments that have been made by Florida Blue, who is the primary defendant in the case, we have added the state and included the state as a nominal party, which I believe we're permitted to do under Florida law. Yes, sir.
On the independent judgment issue that you had raised, Perlow and those other cases, most of those seem to be in a family law context or in some kind of fact-finding context. So if a judge adopts wholesale somebody else's view, one of the parties' views of the facts, I can understand how that can be problematic without some reflection. But on a motion to dismiss, couldn't the judge here have just said granted? Would have been a one-page order, motion to dismiss is granted, given us no rationale or reasoning, and that still would have been fine. And then both sides would sort through what the rationale and reasoning were. But there's different kind of judgment here. It's a legal issue as opposed to a factual issue, I guess is what I'm trying to get at.
And Your Honor's raised a couple different points, and I think first and foremost, I'd agree with the court that some of the cases are summary judgment cases or family law cases where the court's making findings of fact. In this particular case, the trial judge below did in fact sign orders in DSGI or the department's order that was 9 pages without making any edit whatsoever. And the Florida Supreme Court has set forth that test and didn't state in Perlow or any of its progeny that it only applies in summary judgment cases. In fact, some of the cases deal with the cases relied upon by the department. The Cole-Taylor case is in a setting where Judge Foster in Nassau County had a bench trial and had previously entered a summary judgment, and the court went back and looked at some of the prior rulings of the court and the ruling of Judge Foster from the bench trial and applied the same analysis to the summary judgment proceeding as it did to the bench trial proceeding. And so our position, Your Honor, is simply that the factors that the Florida Supreme Court has set forth and that the courts apply in the King case that we cited in our brief and all the cases apply. Those are the factors the court must apply here when analyzing whether the court exercised independent judgment. And I think it's it's important in the context of once the court starts reviewing the 9-page order and sees what the court did. In this particular case, Your Honors, the trial court issued an order and said on page 1500 of the record that the court cites to paragraph 39 of the second amended complaint, and we address this in a footnote in our answer brief, and finds that, quote, the grandmother paid $96,950 of RH's residential stays, with a citation to paragraph 39. The entirety of the second amended complaint says nothing about $96,950 or a grandmother paying anything. That's just what the state injected into the proposed order that they drafted, because that's their theory of the case and why we're all here, because they continue to suggest that that's the basis of the complaint and that's what's being sued for. And there are multiple errors where the trial court kept citing to paragraphs in the second amended complaint in its order that it signed that was submitted by the department. And those paragraphs don't stand for the proposition that the court finds those paragraphs state in the order. And so when those types of errors are made, that's what I think highlights the issues with not exercising independent judgment and why the Florida Supreme Court set forth that test.
Is it fair for us to consider how engaged Judge Marsh was during the proceedings? He talks about receiving some pre-hearing submissions, I think 2 binders, asked questions throughout the proceedings, seems pretty engaged and pretty aware of the issues. Is that a fair consideration in determining whether he exercised independent judgment?
I would answer that 2 ways, Your Honor. Rationally speaking, I would say that for any trial judge to be engaged at the hearing, it makes sense that they were in fact engaged. But the question that the court employs on independent decision-making doesn't focus on what the court said at the hearing, except if the court is instructing the parties and informing the parties as to its decisions with respect to either findings of fact or conclusions of law. Here, the record is completely devoid of that. There is no instruction from the court other than telling the parties, submit your proposed orders in Word, and I'm advising you now that I may take some from one and some for the other, but it's not going to be essentially what he did, a wholesale adoption of one or the other. So the factors that the Florida Supreme Court laid out, Your Honor, and Perlow and its progeny don't address that discussion of, well, is the court engaged in asking questions at the hearing? It focuses more on the judgment. Are you informing the parties of what your rulings are? And if you're not, that's fine, that happens. If you're taking proposed orders, one of the factors is, are you giving each side time to object to each other's orders? Well, here you're talking about a day and a half time period before, from the time the orders were submitted to the time they were signed. So there was no time to object. And then, again, Your Honor, with all the errors that we have, the cases that are relied upon even by the state in their brief, the Cole-Taylor case from this court and the Bishop case from the Second DCA, we think highlight this issue in the arguments. In the Cole-Taylor case, the first DCA was dealing with the opinion or the order that I referenced earlier from Judge Foster. Judge Foster actually wrote a letter to the parties after the hearing, telling them what his findings were and asking them to prepare a ruling. And there was an actual finding by the court that there was no basis to argue a lack of independent decision-making because there was an opportunity to object to the proposed orders.
How could there be an independent, I mean, why are we even having this discussion in the context of a legal determination, an assessment of the pleadings? As Judge Bilbrey just said, he could have said nothing, and we'd still be on review and assessing whether he was legally correct. And as you're answering that, can also tell me, going back to the nominal party question, let's say your complaint is allowed to go forward in the trial court and both parties, Blue Cross and the department, remain as defendants. What would be the effect of a judgment against, I guess, just Blue Cross Blue Shield?
The Blue Cross Blue Shield would be subject to the judgment. And
well, what about the department?
well, the important piece of that, Your Honor, is we're not asking for any judgment against the department. So there's nothing that we're asking the department to do. The relief that we're seeking is to stop Florida
Right.
Blue.
And this appeal has to do with the order dismissing the complaint against the department.
That's correct, Your Honor.
And I think it's arguable that you haven't filed a complaint against the department. Just naming someone in the caption is not suing an entity or a party. And if you're not seeking any relief, you're not seeking any judgment, then what is the harm that was caused by the dismissal of a party that you're not seeking relief against?
Your Honor, I don't necessarily disagree with anything the court just said. I just know that a longstanding practice in the state of Florida and Florida law allows for adding nominal parties to cases when they
Is that a
have an interest.
statute, a rule? The Florida Supreme Court has said that you can just name someone and not seek relief?
No, Your Honor, I'm not aware of a case that
Right.
says that.
It's just lawyers do it, and no one's questioned you on it before.
Certainly would love to see an opinion addressing that issue, Your
Well, along
Honor.
those
but-
lines, why isn't the department immune? Like, why isn't sovereign immunity bar anything against the department at this point?
Your Honor, that issue is not raised and is not subject to this appeal and was not briefed by the parties.
But it's the same thing as arguing exhaustion administrative remedies. That's what it, in reality, that's what that is exhaustion has to do with the legislature authorizing a suit against itself and specifying where that litigation is going to happen. There hasn't been any authorization, as far as I can tell, for a suit to be filed against the department with respect to insurance. Can you identify something that says otherwise?
Again, Your Honor, that wasn't an issue briefed or argued by the parties. The argument on exhaustion of administrative remedies raised by the state was simply that Florida Blues argued, which is by virtue of the case going in front of the administrative law judge and having certain arguments raised and addressed by an administrative law judge, that not appealing that decision was a failure to exhaust administrative remedies. So that argument's not before the court.
Except that
And
it
not
is.
briefed,
I mean,
and I
it's not
certainly would
mentioned.
love to brief that issue, Your Honor. But Your Honor makes another good point, and I know Judge Bilbrey was getting to this as well. So why are we here if we're just dealing with independent decision-making? It's not just that. And I know there are cases out there that suggest that if they find the factors that the court didn't employ independent decision-making, they send it back. But here we've got more than that, and that's the second issue that we've raised, which is the court dismissed all the class action allegations that were pled in the complaint on an order on dismissal. And when we raise under Rule 1.220, the court can't do that. There's supposed to be a hearing, you're supposed to allow for discovery.
Well, but as it relates, and I know we're about through all of your time, including your rebuttal time, so we'll give you some more time, but as it relates, at least to the department, if you don't have a claim against them, how can you be a class representative for no cause of action?
But that's the interesting point, Your Honor, is the state is making the argument really on behalf of Florida Blue that we shouldn't be able to bring the class claims against Florida Blue. I see that my time has expired, Your
Sure.
Honor.
And why don't we add 5 more minutes to your side and 5 more minutes to the state or to the department if they need it. And
Then I appreciate the time, Your Honor, and I'll take 1 more minute, and then I'll cede the rest of my time for rebuttal. The case relied upon in the brief by the state is the Mills case. And what the state says, what the department says, is, and this is on page 31 and 32 of the answer brief, they say to this court, certification was not appropriate even if Harrison proved his allegations, and that class discovery is not required in such circumstances. And they cite the Mills case, but Your Honor, Mills does not support their position. Mills says exactly what we're saying to this court. Mills, the 11th Circuit, reversed a district court for dismissing a complaint at the pleading stage and dismissing the class allegations and not allowing for the discovery and the hearing that's required. And that was under Rule 23, which is parallel to the Rule 1.220. And also under Rule 1.220 D1, there is a process that should have been employed by the court before dismissing a complaint containing class allegations. And we'll save the rest of our time for rebuttal. Thank you, Your
thank you.
Honor.
We've added 5 minutes to the department's time. You were asking earlier in the motion for just 10 minutes, so don't feel compelled to use all 20. But you have it if you need it.
Thank you, Your Honor. May it please the court, my name is Viveka Sapaya, and I will argue on behalf of the Department of Management Services. Today we are here because appellant has taken advantage of this court's ruling in Harrison 1 to repackage claims that have failed time and time again. To affirm the trial court, this court only needs to focus on 2 issues. And the first is the standard for reversing a trial court's order, and the second being appellant's fundamental failure to exhaust administrative remedies. Your Honors, before I delve into the 2 issues, I want to talk about the history of this case. This case was born nearly 10 years ago in 2015 after appellant's daughter received treatment at a facility outside of Florida Blue's provider network.
Can you jump ahead and address why isn't the department claiming that it's immune from suit? Or should I say, why it's not claiming it's immune from a non-suit against it? Because apparently the plaintiffs are not seeking relief against the department.
Your Honor, the department is not immune in the sense that even though opposing counsel has said that they're really here today to bring suit against Florida Blue, they even concede that they're required to name the department as a party because according to Chapter 120, the department is the one that is the final arbiter on this on this issue today. And
Where
Florida
does it
Blue,
say that in Chapter 120 specifically?
Florida Statutes, Chapter 120.123, subsection 5, Your Honor, discusses the processes for an administrative hearing and talks about how a contractor like Florida Blue that has contracted with the department is only responsible in terms of being a plan administrator. And that's why even at the administrative level, when appellant brought their claim for medical coverage, any decision made by the administrative law judge there was also binding on Florida Blue. And that's why Florida Blue...
How is that? I mean, we're getting a couple layers in, but maybe we can jump ahead to how an administrative law judge in the executive branch can issue an order that would have any effect outside the executive branch and be binding on the judicial branch. Which is what you're saying by arguing that the ALJ's order or the department's final agency action has res judicata effect in the trial court. So how could that be?
Your Honor, the administrative framework laid out in Chapter 120.1235 is a full adjudication. So their appellant did have an opportunity to litigate the issues in terms of not only a denial of medical coverage for his daughter's stay, but also these other issues. And I know that appellant is making the arguments that adding claims such as negligence, negligent misrepresentation, and breach of fiduciary duty are completely different and save this case from res judicata analysis. But the reality is, none of the questions required for negligence, negligent misrepresentation, or a breach of fiduciary duty, we can't ask any of the questions there without asking the first question of, was denial of medical coverage proper? And so since that was already litigated at the administrative level, not only is the department bound by that judgment, appellant bound by that judgment, but Florida Blue as a privy is also bound by that judgment.
Go ahead.
I don't understand what it means to be bound. Like, how can a trial court be bound by the executive branch and administrative hearing officer? That's my question. I mean, it's an administrative order, so it's related to, I guess, that they've claimed a public right in some way or a public benefit through state insurance. And I understand you go through the department because the department, through the division, administers the program. That's fine, I get it. And they've gone through that. They've gone through the entire process. They got an order. An order says no. That's all well and good. To argue that that's res judicata and in some way binding outside of the executive branch seems to be a separation of powers problem. And I'm trying to understand why the department continues to argue that an administrative hearing officer's order has any effect on the exercise of judicial power by a circuit court judge.
Your Honor, I think that that's because this argument is being made in terms of res judicata because that finding of the denial of medical coverage at the administrative level still travels with this case at the trial court level. So
Why? Based on what?
According to Florida statutes, Your Honor, and the power given to the department to adopt this order as a final order, and Florida statutes giving the department that status of being the final arbiter here on the question of whether the medical claim coverage was proper or denial was proper. That is what, so from the legislature really is where the department gets that authority.
Right.
And
the legislature said that really through just generally Chapter 120 and without because it did not make an exception and say that you can be sued in circuit court over this, that the legislature said that your sole avenue to seek relief with respect to this public benefit under state insurance is through the administrative process.
Yes, Your Honor.
So in other words, aren't you immune from suit in circuit court because the legislature has not waived sovereign immunity, which it has to do before the department can be sued?
Yes, Your Honor, but since appellant is trying to bring suit against Florida Blue here as well.
But that's not this appeal, that's the next one.
That's correct, Your Honor.
But what's the department's position, though, as to whether it should even still be, assuming that there are some viable causes of action against Blue Cross that we'll get to in the next appeal, but even if there are, why should the department stay in the case?
Your Honor, I think the best authority here to answer that question is the AMEC 1 case, AMEC Civil LLC versus State of Florida, which there, the contractor is in the same position that Florida Blue is in with the department today. And as a subcontractor, as a privy, we travel together in this case and have been traveling together for since 2018.
Well, and I guess my question is more what Judge Tannenbaum and I were asking early on your opponent. why, there's no damages, no remedies being sought against the department. So should the department remain in the case? I understand that you claim privity with BCBS and that y'all should travel together, and the issues of res judicata and the contract and all of that relate to both of you equally. I understand that. But why should you even be in the action at all if there are no damages, no remedy, no injunction, nothing being sought against the department?
DMS should remain in the sense that as a privy, Florida Blue, and as a third-party administrator, really, Florida Blue is really just administering the funds that are in the hands of the department. Requesting relief from Florida Blue when Florida Blue is only a third-party administrator, and really applying these criteria to administer funds that are in the hands of the department.
Why can't Florida Blue make that argument then? Is that they shouldn't be, I mean, I think they are making that argument in the next appeal, so.
Yes, Your Honor.
But it sounds like the department doesn't trust Blue Cross to make that argument, so the department feels like it needs to come in and make the better argument of the same thing. Is that the position of the department?
No, Your Honor.
So then why does the department need to be in the suit? Unless, wouldn't the better approach have been for the department not to be sued? And if you're concerned about any issues or interests of the state being litigated, you seek to intervene. And if it's granted, well, guess what? Now you're really a defendant, and you're named in one or more of the counts, I guess. And
Yes.
then you can litigate.
Yes, Your Honor, that would have been another way to approach, but as this case was not consolidated at this level, and we were also named as a party by appellant, we're here litigating today.
Named as a party nominally in the circuit court. And no one has still yet explained what the significance is of having one's name in a caption in a lawsuit. How is that even, I mean, that doesn't even call or invoke the exercise of judicial power against a party. I'm not even sure there would be personal jurisdiction if such a thing existed, with respect to the state. But it's just very confusing as to what this lawsuit is all about. So we have the appellant saying, well, we feel like we needed to name the department as a party because we were afraid that they were going to argue that they were indispensable, or that Blue Cross was going to say they were indispensable. But we're not going to seek any relief against them. And then we have the department saying, well, yeah, we should be a nominal party. We should be in the case. But we're fine, not having any relief, but we're still going to litigate on appeal. Can you explain what this litigation is all about with respect to the department? If the judgment ultimately would have no effect and not be binding or anything with respect to the department?
Your Honor, I think it really just goes back to the relationship between Florida Blue and the department, and the reason that appellant named the department even in a nominal sense is because of that fear that they would later be required to add it back in as an indispensable party. But before I also want to address, Your Honors, the first point that appellant made today in terms of Judge Marsh's lack of independent judgment being a reason why the order should be dismissed. They're taking the four-factor test from the King versus Farah and Farah case, and although appellant did not specify what exactly these factors are, they are the length and detail of the proposal, whether the parties were given any opportunity to object to each other's submissions, how long it took for the trial judge to adopt the proposal, and whether the trial judge made findings of fact and conclusions of law on the record to guide the parties' preparation of their respective submissions.
And it seems like most of those would weigh against the department, right?
No, Your Honor. Of these factors, appellant only specifically takes issue with the length of time it took for the trial judge to adopt appellee's proposed orders and the fact that adoption of the orders was verbatim. And the factors do not create a bright-line rule that orders adopted verbatim should be reversed, nor do they state that a proposed order must be considered for any given amount of time before being accepted. The reality is Judge Marsh's verbatim adoption of appellee's orders came after thorough research into the record. I know there was a question asked of whether or not Judge Marsh's engagement during the proceeding should be considered, and it should, because that is part and parcel of guidance that Judge Marsh is giving to parties in terms of preparing their submissions.
Doesn't saying that the judge researched into the record cut against the whole point of what a motion to dismiss is? Shouldn't his engagement been limited to reviewing the complaint, or the Second Amendment complaint, and determining whether it states a cause of action?
In terms of exercising an independent judgment, Your Honor, engaging with the record, asking questions, which is what Judge Marsh did during this proceeding, is just evidence of being of a judge that is exercising independent judgment. Which even after asking these questions, being able to go back to the complaint and say, hey, this is not sufficient, that is still, again, an independent exercise of judgment. Your Honors, I know that appellant cited a couple of cases, the Perlow versus Berg-Perlow, West versus West, and King versus Farah and Farah. And in all of those cases are distinguishable from what we have here today, because there the trial judge either actively discouraged one side from submitting a proposed order, did not allow each side to see the other side's proposed order, or did not solicit a proposed order from one side, period. And here, Judge Marsh gave ample opportunity for appellant to make their case and objections. And that's evidenced by the fact that of the 6 proposed orders collected, 3 of the orders were from appellant. And appellant even exercised a motion for rehearing, which was duly denied by Judge Marsh because appellant could not specify exactly which provisions of Judge Marsh's adopted orders contained conflicting information or inconsistencies. And they mentioned an inconsistency today about the amount of money that was requested by appellant, not being there in the SAC.
Can I ask you about the motion for rehearing? The motion for rehearing that was filed in the department's case did not mention the law of the case issue that is raised in the Blue Cross Blue Shield motion for rehearing. Is that issue then, which I think is one of the first issues in the briefing here, is that issue preserved?
Yes, Your Honor, because it still travels with the fact that it still travels with the department's point on failure to exhaust administrative remedies. The denial of medical coverage still travels with these claims.
What is the, well, first of all, what is the law of the case in, can you identify that part of the opinion that actually makes some sort of legal holding that matter to the disposition that you consider to be controlling here?
Your Honor, this court in the first, in Harrison 1, affirmed the trial court's order in its entirety except
that it didn't, because it ended up reversing it. So what does it mean to affirm an order that you then reverse?
Your Honor, it was only reversed in terms of the leave to amend. And appellant today is relying...
Which means that it so the order on appeal was a dismissal with prejudice. That was reversed. That means that the order didn't exist anymore. It was sent back to give the plaintiffs another opportunity to amend the complaint. That means that the only thing relevant to that disposition was the fact that the trial judge supposedly made some determinations as a matter of law that potentially were disputes of fact. That was the rationale for reversing. What's the rest of the law of the case? Like, how can an appellate court affirm something that it then reverses and have that be law of the case?
Your Honor, in Harrison 1, this court did not make a endorsement of any of appellant's proposed amendments. So
It also didn't endorse anything in the order specifically either.
Your Honor, even in that situation, Judge Marsh's order of dismissal, which is finding that that there's no claim here, and that the claims are barred by res judicata and collateral estoppel, those still stand because even when given the opportunity to amend their complaint, appellant did not meet the legal standard necessary. And that goes back to the fact that at the point where they were denied medical coverage in the administrative context, instead of following through with an appeal to this court in 2017, they decided to climb out of the administrative framework and bring suit in circuit court. And that really taints all of their claims today.
Is it the department's position that, yes, it should have been sued, and so it was properly named as a nominal party, but yes, then the trial court properly dismissed the department as a nominal party? Is that the department's position?
Your Honor, the department's position is that is because of that fundamental failure that appellant did not take advantage of the appeal at the administrative level, this claim that they're trying to bring in trial court in 2019 and again here.
But not against the department, against Blue Cross.
Right, but even
Which
then,
wasn't
Your
a
Honor,
party, is a private entity.
who would
It's
not,
not subject to DOA and its jurisdiction in the executive branch.
but since Florida Blue acts as a privy with the department, Florida Blue is here as a third-party administrator. Florida Blue is only administrating the funds that are within the hands of the department. So for the department is involved in the sense that any money that's going out in these plans and these claims is from the department. So Florida Blue, as a third-party administrator, is within the wings of the department. Your Honor, I see that my time is about to, or is close to coming to an end, so if there aren't any further questions.
I have one.
Okay.
So this business about you don't exhaust, it's not exhaustion of administrative remedies unless you take an appeal under 12068. I know that this court has said it a couple times without any analysis, just cites the fourth DCA decision, the FHSAA opinion, which, by the way, didn't have to do with an agency. So what's the rationale behind that? How can a failure to invoke the judicial branch's power, how can that be part of the requirement that you exhaust administrative remedies? Since an appeal under 12068 invokes this court's authority under Article 5, Section 4, how is that an administrative aspect of it?
Your Honor, I think that goes back to how Florida law and Florida statutes preserve these questions that fall within the purview of agencies like the Department of Management Services. Because Florida statutes and Florida law reserves it that way, there's still a way for appellant to come to this court or come to a traditional court and appeal their claims, which here appellant failed to do so. And I think here what's the danger of allowing this to keep continuing on and on and on is that there's this precedent of maybe if we don't pursue appeal at the critical question of is there a proper denial of medical coverage, and instead repackage these claims in different flavors and bring them to a circuit court, we can survive the administrative framework and avoid judgment at the administrative level, and maybe perhaps get a different judgment at the trial level, get a second bite of the apple. In Your Honors, I see I have 30 seconds remaining, so.
It's actually 30 seconds, 43 seconds over now, but
Oh,
that's okay.
perfect.
You can conclude if you like.
Okay. If there are no further questions, Your Honors. Because Judge Marsh's orders met standards for consistency, fairness, and was supported by the record, and because appellant cannot support his current claims without relitigating the decided issue of coverage denial, we ask this court to affirm the trial court's decision and put this case to rest. Thank you.
Counsel. Why don't we add one more minute then to rebuttal?
Your Honors, I want to address one point on rebuttal, and that is, just like the briefing that we received on this issue of the dismissal of the class allegations, here today, appellee, the department has not addressed the fact that Judge Marsh dismissed all the class allegations in the case that they rely on in their brief, the Mills case. stands for the same proposition of all the cases we've cited, which says it's improper. And Judge Marsh went even further when Your Honor's reviewed the order that Judge Marsh entered granting dismissal for the department. Not only did Judge Marsh say that we failed to prove commonality, typicality, the things that are required to be proved for class allegations, he found that we failed to prove them.
Is class allegations a separate count? Is that a separate form of relief? Or is there a procedural mechanism to make, with roots in equity, to make the judgment effective virtually, I guess, across
That's a good question.
parties that aren't there, actually?
And Judge, having dealt with that on both the plaintiff and the defense side in class actions, sometimes they're pled together individually on behalf of the class in one count. Sometimes they're separated out. More often than not, they're separated out. We
Well,
had
the reason
7 count. Yes, sir.
I mean, but the reason for my question is look, I mean, the trial judge dismissed your Second Amendment complaint on some legal grounds.
Yes, sir.
We may agree with one or more of those legal grounds. If we do, what's the difference whether he also struck the class allegations?
The difference being, Your Honor, in those circumstances, what the courts say is that the party should be allowed to conduct discovery and allowed to find time, in given time, to find another class representative. So it would depend on what the legal basis was that
But
this
you're not
court was
precluded.
affirming.
You're not precluded from finding other another representative plaintiff
Oh, we most certainly would be, Your Honor, because
How?
the case is dismissed with prejudice.
against your client, the current client.
Yes, Your Honor.
That doesn't, because there wasn't any class determination, that can't have any effect on any other party.
Oh, it certainly.
Or a potential plaintiff.
The way it works, Your Honor, in this particular instance is it would have, right now, we filed a complaint that's been pending for a long time. We've had a couple of appeals. The class period that we'd be able to plead on behalf of this class that would or would not be subject to statute of limitations and those sorts of claims would be one set of statute of limitations in this case and one time period in this case. If the case is dismissed with prejudice and somebody 2 months from now filed a new class action, they wouldn't be able to go back as far, and all those individuals who would be subject to the class claims in this case would lose their rights.
That sounds like a concession that over the, I don't know how many years this thing has been pending, that there's not been any work done to identify any other potential member of the class. I mean, that could have been done years ago.
Absolutely. We tried, Your Honor, and as Your Honor will note in the record, we've been denied any discovery because the trial court entered an order precluding any discovery in this case. So we haven't been able to conduct any discovery. But I would agree with Your Honor. Typically, that's what you'd be able to do.
But are you arguing contrary? There's a Florida Supreme Court case, Sosa, which I don't think anybody cited. There's a case that I relied on called Ahern that cited that. If you don't have a viable claim as class representative, you don't have a class. So why does all this class stuff matter if Harrison doesn't have a viable claim?
And I think Sosa and Ahern, and this is, that wasn't from this case, but I'm going off my memory, were more standing issues for the class representative and whether the class representative had an injury in fact.
Yeah, they were picking off issues actually where the defendants came and picked off the class representative, and then could they still proceed with the case? But the main theory was you still had to have a cause of action as an individual to be able to proceed for the class.
Yes, Your Honor, and that's a standing issue, and we would assert and will argue in the next appeal this issue of standing and injury in fact. And part of the issue that we keep hearing is, and we just heard it with the rebuttal, I see that my time's concluding.
Sure.
May I
Go
answer
ahead.
the question and conclude? The argument that we heard from Appelli just a moment ago is that we're making the same arguments we made in the administrative case and we're seeking the same relief. That is what the trial court found in its order, and yet it didn't cite to anywhere in the second amended complaint where we're doing that. We're not seeking the recovery of the denial of benefits. That's nowhere in the second amended complaint. But that's their theory that they continue to push in their argument that the trial court adopted without anywhere in the record stating that. So we have an injury of fact. They haven't served interrogatories, requests for production as to our pleading of damages, our general pleading of damages, where we could describe what we're pleading. But we're here on a motion to dismiss, and we haven't even gotten there.
Thank you, counsel.
Thank you, Your Honor.